The Supreme Court says it will consider a Tennessee law banning gender-affirming health care for transgender minors in its next term. The plaintiffs claim the law violates 14th Amendment equal protection and due process clauses. A decision could come by the end of next June. For more on this, let's bring in Fred Smith. He's a constitutional law expert and professor of law at Emory University. Fred, thank you for joining us. The court has largely stayed out of gender disputes, with the exception of a surprise 2020 ruling that blocks employers discriminating against transgender people. Why is it taking up this case?
Yeah, there's a few possible reasons. One is that the United States Solicitor General brought this particular petition. So the case below was brought by a number of families. The primary attorneys were Lambda Legal. The cert petition that the court granted, though, was filed by the United States government. And anytime the Solicitor General files a cert petition, it's going to get extra weight. It's also the case now that there is what we call a split of authority, where some federal courts have come out one way, other federal courts have come out another way. Most federal courts have concluded that these laws are unconstitutional under the Equal Protection Clause because of the way that they're written. But now the Sixth Circuit has reached a different conclusion, and circuit splits are another time that you see the court intervene.
Fred, in September, the federal judge who upheld this Tennessee law said the state is not denying the existence of gender dysphoria or the feeling of distress in those who don't identify with their biologically assigned gender, but he ruled elected officials should be able to restrict minors from seeking treatment for it. Is this part of what you're talking about there with the way these laws are written?
Yeah, so the issue is that these particular treatments, hormones and puberty blockers, they are allowed to be given, including in the state of Tennessee, as long as they're not being given to someone who has gender dysphoria. So if someone were maturing fast for their age, this would be permissible. If there was a young male and a doctor decided that they wanted to give the young male more testosterone in order to conform more to their biological sex, that would be permitted. It's only prohibited if the purpose is gender dysphoria, and that's why most courts have concluded that this is sex discrimination.
We mentioned that courts have typically stayed out of these disputes off the top, barring that 2020 case and then this most recent one. Do you expect the number of cases like this will increase?
Well, I think what's likely, there's already a lot of these cases, and I think what's likely is that the Supreme Court is going to, at least for now, settle the issue. There's 20 laws of this type across the country. And in about 85% of the cases, preliminary injunctions have been entered that stopped those laws from going into effect. What we'll learn now from the Supreme Court is whether or not that will continue to be true, right? So this is going to really, for now, settle the issue and either put an end to these lawsuits for now or make it clear that they are, in fact, unconstitutional.
It does seem like it's coming to a head, though, right? Like the Supreme Court at some point needs to step in and say one way or the other.
I think that's right. There's a lot of families across the country who don't really know what they're supposed to do. They're getting medical treatment. They're getting medical advice from doctors that are going one way, and then they have their legislature telling them something else. And so I think that one reason, again, that the court also might have taken this issue is just its sheer importance in light of that.
Parents being confused, doctors being confused for that matter as well. All right, Fred Smith, thank you very much. Appreciate it.
Thank you.